Happy Tuesday, guys. We are live. It is Kayla McDonald with Remax Alliance Group, and we have Miss Lindsay Weber with Keystone Mortgage Solutions.
Oh, hello.
Today we have Tiffani Thornton on. She's the owner of the law office of Tiffani Thornton. And she does estate planning, real estate law, probate, all the fun
All
things.
the fun stuff.
Yeah. So, um, I'm going to turn it over to you. When did you start your practice? Obviously, you have a lot of education and a lot of things you have to go through before you can be licensed. How did you get started, and what led you to this specific niche? In the law world.
Yeah, so I have been owning my own firm for a little over a year now. I started in March of last year, and it's been wonderful ever since. And I'm really looking forward to the forward trajectory of the firm. Prior to that, I worked at another firm in civil litigation. And prior to that, I was an assistant attorney general for the state of Florida, handling child welfare cases. The trajectory to kind of getting here in the path, as for a lot of professionals, it's not a straight and narrow path. It's something that finds you. You don't necessarily find it. I have been working in the legal field now for over 10 years. Back about 11 years ago now, I was working for a firm just like mine, a solo attorney that was in St. Pete while I was a junior at the University of South Florida. And I was doing all kinds of stuff. I was helping put together paperwork. I was helping take notes on client matters, helping do research. And I was there to learn, but that's kind of where the bug of real estate law kind of bit me there. I didn't go to law school right out of graduating from college. I took about a year and a half to work at the university. Then I went to law school. While I was in law school, I got a job at a firm that did personal injury, criminal defense, but also real estate law. So I got to see a lot of unique information and a lot of unique cases come through at that time while I was a student. So it was great. Unlike a lot of people in law school, I liked property law. Most people don't like it for a lot of reasons in terms of how it's taught and the things you have to learn. But I liked it and it was great. But I also wanted to be a public servant for a while when I graduated. So that's why I went to the Attorney General's office. And I was able to be dedicated to that for about my first year of practice before moving on into civil and doing civil litigation. So my background is the law. I've spent time getting to know the law. I spent time getting to know kind of what outcomes look like in cases, what ideal outcomes look like, but also the practical. I've been fortunate to have matters and to work in places where I was always really close to the client, always got to know what the client wanted, what they were thinking, what their pain points were. And so over time, you start to learn a pattern for that. And you don't fit your new clients into molds, but you're prepared for them to potentially look like the one you saw in the past. And that's really what I've done for the past year of my own practice, as well as now for the past approximately 4 years that I've been a licensed attorney in Florida. I'm a COVID lawyer. So I got my license during a time where things were still shut down. And Zoom court was happening. I was in that first batch of attorneys to do Zoom court. I was the last in-person bar exam. So it was a very unique time to come into the law and start working on all of these things as the attorney and as the person driving the ship versus back in the past being the legal clerk or being a legal assistant. So that's where I come from. And a lot of times with my firm and my matters, I say I'm a problem solver. I know how to litigate. I'm educated on how to litigate. I got my trial training from the Attorney General's office, but at the same time, that's not always appropriate for everything. And I find that a lot of clients who come to my firm are comforted by that, they know that what they want to see happen is what I'm going to work for. We're not just going to litigate it to death. We're not going to chase judgments that don't get collected. We're going to figure out what works for them. And that's what we're going to do. So that's the law office of Tiffani Thornton. I have a small staff and we try to keep it really close knit, not have a lot of administrative issues for clients to go through, make sure they know on a named basis who they're talking to, and know that they can always get through to me if they really need something that my staff can't help them with.
So that's so funny that you said you're a COVID lawyer. I kind of feel like that's how I am because I got started class. So I was actually at school for my real estate license, and they thankfully let us finish our class because they shut everything down. And our class was small enough that they allowed us to finish the last, I think, 2 days of our class and take our test and everything. So that's basically, I got started right, right as COVID began, and I was like, oh man, I don't know if you felt this way. I'm like, this is like the worst time to be starting something new. But it ended up, I feel like for me, it ended up like catapulting everything. And, we figured things out in such like a weird, unique time. So yeah, that's cool. Yeah, I did not know that. So when you have, what's like a typical client? This is probably a difficult question for you because I'm sure you get a plethora of them. For like just like someone who's not estate planning or is not a probate client, do you work with both buyers and sellers if they have an issue, like in a contract, during a contract, post contract, all of the above?
Yes, it is all the above. And honestly, I wish it was all of the above more often. And I'm very transparent when I do like field or agent education, broker education stuff. I host those at my office. I go into brokerages and do it. I'm really transparent about. I always wish every file that I see, I wish I would have gotten it earlier. I had a consult before I got on today, and I was like, oh my goodness, I wish we would have met you before you went through what you went through, because we could have potentially avoided some stuff, even with transactions. And I promise I'm going to get to your question because I'm a lawyer, so I remember it. But it just brings up the thought that, even with transactions, it's like, usually the agents know when something's starting to go off the rails, and it's like, just refer them out. I don't care if they come to my firm, refer them to somebody, because chances are that attorney can help them cut through it and figure out what to do. But unfortunately, I don't get enough of those. So instead, what I get is, we can't close, the other person won't close, something came up and we want the deposit or they want the deposit, and now we're in an issue. We need a demand letter issued. We need to go to mediation. And obviously, worst case scenario, we're looking at litigation. And I say worst case scenario because I think that's always the worst case scenario, honestly. As a litigator, I always say I'm trained on go. I'm trained to fight. We all are. But that's not always the best thing. So as a human, I recognize that that's not, the best outcome for a lot of situations, because even if you go fight someone and you win, they may not, who voluntarily cuts a check, who says, all right, you got me, here's a check for the money. You have to usually fight for the money too. If it's a EMD dispute and it's with a title company, you're going to get a court order that says the title company has to hand it over. But what about all your legal fees you paid, right? Yeah. So those things come up. But yes, typically those deposit issues, I get, here and there, I get failure to disclose issues come in through my intake of, issues with properties. Usually it'll be termites or water leaks and damage, really bad structural stuff. And those are ones I take my time with and try to help the buyers. Typically are the ones figuring out what to do, because again, the same question comes up. Well, you have potentially a $50,000, $100,000 issue with your property. Do you want to pay that much in legal fees to fight it? Can we work with the other side to try to get you some kind of a reasonable payout? Or do we have to go down that path? Talk about evidence, talk about if there's good or bad evidence, things like that that happen. A lot of my intakes and files right now actually are, I wouldn't say directly on the estate planning and probate end, because I think the agents and the title companies that are looking at them don't immediately recognize them to be probate or to be basically title defects that sometimes can lead us down that path. But then when we get into it and evaluate it, they turn out to be. So I do a lot of consults with folks who are in probate, or who think they're done with probate, or who think they got property through a trust or a ladybird deed, but something was wrong. And depending on what the underwriters of the title company are looking for, they may say you need probate, or they may say you need quiet title. And then when they come to me, we're looking at multiple layers. We're looking at a real estate path of validity of a deed, sometimes validity of a trust, and the ways that you go through to cure those kind of things if you can. And then sometimes we can be looking at probate if it is applicable. So sometimes the way something presents or it feels like when I start digging and evaluating it, it turns out not to be that. And it's tough because then I have to tell the client, actually it's looking like this. And, at the same time, I never want to offend, the agents or the title agents who worked hard in the matter to try to advise that individual. But that's just another reason to kind of hand those off early if something's coming up and you don't know how to cut through it. Because I hate that situation where they've been told by, say, underwriting, you need probate. And they're like, no, you need quiet title. And they're like, well, which one of you is right? And it's like, well, we're both right, actually. But in terms of what the legal system wants you to do, it is going to be what I'm saying. If you do what the title agent's saying, the legal system may not actually want you to do that. You may not get what you're asking for from the court then. It's just very interesting to see those things come up. And it's interesting in an academic sense. It's not interesting in the sense that it's still a tough time for that client.
Oh yeah, because the buyer and the seller, whoever's involved, it's still interesting, but it's difficult and probably not fun, especially depending on which way it's leaning towards. So the disputes on disclosing, that's what's interesting to me, because I see things on Facebook all the time from people who just bought a house and then they find something happens or something breaks or something goes wrong. And, everybody, I'm not going to say everybody, but I feel like people are just so like, who can I sue for this? And how can I, get this fixed? And sometimes, I'm sure you see, sometimes it's not the seller's fault.
Yeah.
Sometimes it's just normal wear and tear, and things happen when you buy a house. And then other times, I've heard people say like they found mold in their walls, and I feel like that's really hard. And I'm sure for you, that's hard for you to comb through and see if there truly is a case there. Mm-hmm. Because that's tough.
It is. I mean, there's a lot to unpack to even give more context for that, because it's an interesting topic. When it comes to failure to disclose, you have to look at multiple aspects of it in terms of the law. There's a certain amount of case law and a certain elements that have to be met. And that's where, something that's interesting as attorneys, and I think we need to watch ourselves sometimes. We tend to say you have a case or you don't have a case, right? And I've actually kind of stopped myself from using that language because I think it can mislead the clients and the potential clients sometimes. Because what I mean by what we mean as legal profession by you have a case is I can write a complaint that alleges all the elements of a misrepresentation, or we call it Johnson v. Davis claim in the law. I can write, I think it's 5 elements. I can write those 5 elements and not get sanctioned because you've given me enough information that it kind of fits the bare basic mold. But that doesn't mean that once we file that, right, we go into court, the other side's going to respond. We're going to engage in discovery. So documents are going to fly back and forth. The other side's going to have some legal arguments, the best they can get. Maybe they have great opposition, maybe they don't. That's going to happen. And then what do we have, right? Is it a situation where you're still sitting, in a great position in terms of your evidence and your legal claim, which again is not just putting the words on the paper. That's easy to do. But it's also making sure you can substantiate it. And with failure to disclose specifically, you've got to show that that seller knew or should have known about the defect. And that's actually really hard when you think about it, because you weren't in the house with them. So it has to either be so obvious that anybody would, know about it. And you can use, experts like inspectors and folks like that to say what's in there, what it would have looked like. Or, sometimes you have that case where you have admissions by the parties themselves, or you depose them and they start to admit some of those things. But that's a huge component. Materiality is another element that's a big component. So, and I think that goes to your point. Is it something that is just wear and tear? Is it something that compared to the price of the home isn't a big deal? I've seen disputes on homes that are $1 million, $2 million, and we're talking about a $10,000 defect. Well, that's not typically considered material when we talk about that size transaction. A $10,000 defect could be material to, we don't have $50,000 homes anymore, but if we did, it would be material there, right? So we have to look at that. Even with, I say, an average price home, which is probably upper 3s, low 4s, we potentially could say material. But the scratch on the door, you might get laughed out of court. You might on those kind of things. And that's where, sometimes there are folks who, I'll use the internet as an example. They're kind of going around town or around the internet trying to find attorneys. and you kind of start to hear that I can't find an attorney speech. There's a lot of lawyers in Florida.
Yeah.
We all need cases, we all need work because we're in a state where there's so many of us, right?
Mm-hmm.
And so exceptions exist, of course, but I'll say a lot of times when someone can't find an attorney to take their matter, it's not looking great for one reason or the other. You don't know what it is unless they tell you. But if someone's, especially that kind of case, because that kind of case, we presume they're going to go to trial because there's going to be factual disputes about what did you see, what did you know? And when you do that, obviously you're billing on the file. It's pretty rare for a real estate attorney to take contingency. Some firms do. So maybe either way, there's a big payday for the attorney, right? So if you have a good failure to disclose case, somebody's going to take that case.
Right.
But if there's some issues in it, whether they can be overcome or not, you're going to have trouble, finding counsel. So there's a whole lot in that sphere to look at. And for me, I comb them carefully and I talk through it with people. I have had people with defects that I felt comfortable litigating, but when we talked about the cost of litigating, they weren't comfortable with it. And so they settled or they walked away and said they fix it themselves. And I see that as the client's choice because I don't want to have all your money here. And then I've taken more than the defect cost to remedy. Right. Or we get that judgment. And again, we can't collect it against the other party. That can happen when properties are held in LLCs or land trusts and it's an investor flip. Yes, there are definitely times we can reach past the entity that they're holding the property or we're holding that property in. That's not guaranteed. So that's another thing we try to look at on the front end to make sure that we're as covered as we can be before we take a lot of retainer money and start billing a client for something that we can't tell if we can get what they want to get out of it.
Yeah, it's very, very intricate, and and thankfully I haven't really had a lot of experience with past buyers or sellers wanting to go down that route. Of course, there's always going to be discrepancies, and sometimes I have people calling me like 6 months down the road asking me about something with their house, and I'm like, I don't know. I don't know what happened to your house, or what happened, like why or there's a pipe leaking right now. Like you've been living there for 6 months. Like I don't know what to tell you. Like
get it checked out, get the right contractor or vendor in to look at it, see what they think, and go from there. And for the sellers, the generics, I'm not going to give specific advice on here, of course, but on the internet, right. But the generic advice would be, you get that letter, that phone call, text, email from that buyer or from an attorney representing them. Don't throw it in the trash because the worst outcomes come from that. I'm not saying you just cut a check if you've got it. I'm not saying you cut the blank check, but you have some time to think about it. You have some time to go get counsel of your own to look at it and see. I've been on that side a couple of times, and sometimes you do look at it and you're like, yeah, they're chasing money with, what's not a good case. Let's send them a response saying why it's not, they don't have a good position. And, hopefully they kind of call it a day and everyone moves on. And if they don't, here's the plan and here's how we would defend you. And I've even told people, okay, here's how much my retainer would be to defend you in an action. And this is a hard one to swallow, but rather than you giving me that money, why don't you just give it to that person? And let's see if we can get a settlement done that way. I've done that a few times because, again, I like to take the matters that either, the person kind of needs my help to get through it, to get a resolution one way or the other, or it really needs to be litigated and we have to do that. But otherwise, I try to figure out how do we deal with this in a way where they put their money in the right direction.
You deal with a lot of title issues as far as like encroachment and property lines and stuff like that. Any advice that you could give like a buyer or seller of things that they potentially could look for when they're purchasing a home to avoid anything like that?
Yeah. I like for people to get their own surveys. I know sometimes we see folks that, depending on the type of financing and things like that, they'll be relying on that seller's survey. I like for people to get their own. I understand it's an investment, but again, it's cheaper than me. So go ahead and get that fresh survey. Have, talk to the surveyor, right? And know their methods. I love the ones who, actually go out to the property and take measurements and look and put the rods down or look at where the rods are versus the people who are just looking at the plat. And there's a time and place for both of those. I think also with agents, your neighborhoods. So the neighborhoods that have been around, especially in Tampa Bay, for a while, and maybe things have moved around. Maybe the houses have been there forever. I can tell you some of the areas in Tampa that have these issues. They are near the Port Tampa City area has these issues. North of Ybor City, Seminole Heights area has these issues. We're starting to see these issues crop up near Raymond James Stadium and towards, I would say, what would it be, like south of the airport? I can't name the streets. So south of the airport, towards there's a big
geofence right over here.
Over there near it's south of the airport, in that community, there's some issues because anywhere that, again, you've got older communities, you've got older plats, people may have done handshake deals. And I've learned Tampa has a beautiful history, a beautiful and diverse history where people were doing business with each other on a lot of handshakes 100 years ago. And those things are not always in our records.
It's fine. Put that back there. We'll both use it.
It's one of those things, so it's, and as you know, your neighborhoods, where these things might come up. And that's where I want to see those physical surveys being done so that surveyor can tell you what you have or don't have. I had a case about 2 years ago that the surveys measurements of the lot did not match the physical measurements because the plat had an issue. That's what I'll say. And it was a toughie. And so what it became is the neighbor encroaching, or is that the neighbor's property? Don't know, right? And we were in litigation over it. We were able to resolve that. But those are the kind of things that happen because we did not have that physical measurement survey on the front end. We didn't have a surveyor who actually looked at the plat and compared everything. And we had to get one after the fact to come through and figure it all out for us in the middle of litigation. With encroachments, it depends. That's the example. We've got to make sure it really is an encroachment, because I've had those matters where the other side says, you're encroaching. And your client's like, no, we're not. And then we go get some records and we find out they are. And then it's like, okay, what do we do now? We've had those. And of course you have the true ones. You have the people blocking roads, easement kind of stuff. I try to get through those as reasonably as possible, but sometimes you can't. Sometimes those are just disputed and they have to be litigated until we can either a judge figures it out or we litigate it to the point where people start coming up with ideas on it. And those can be very difficult. HOA cases can be difficult. I tend to not accept a lot of HOA cases unless the person's trying to resolve a situation. Right. So I'll look at the declaration, figure out what's going on, explain to them, you violated or you didn't violate. Here's how you get past it. Then a lot of instances, someone who's saying, I hate my HOA, I want to sue them, is usually not, a client for me. There's only like 1 or 2 firms I can send them to. And that's another example of attorneys not really being interested in those cases. Often not anything they can do. Not in every case, of course, but in a lot of instances, not a lot that attorneys can do for you unless we're going to try to work it out. I have actually represented associations in the past. That was interesting.
HOAs are always fun.
In all of our businesses, it's a lot sometimes.
It can be. It definitely can be. So sometimes my role is just explaining to the client, hey, here's what happened. I won't describe some of the things I've seen, but they've been, they've at least been things we can laugh about. That it's like, you did what to your house? Or you did what? And, here's the declaration. Here's the rule. You can't do that. Don't do it again.
Usually it's because they're already mad about something. So they're like, all right, fine. So I'm going to do this. And it's like something out of, crazy.
And it's human. People do these things. But again, you have to consider that that's what gives people like me a job. So
right.
Which one do you find easier?
Well, because a lot of these declarations are very long and lengthy, and people unfortunately just don't read through them before they purchase the house. And then when it comes time to either, sell the house or, do something, then they're like, what? Nobody ever told me that I couldn't do this or I couldn't do that. I mean, I had one in a 55 and up community earlier this year, and they only allowed open houses on 2 Saturdays of the month. So, if I wanted to do an open house, I wouldn't be able to put up any signs anywhere, because if somebody found it, they could take my sign and just throw it away.
Right.
So, there's like little things like that that people just don't read through or, don't know or don't realize until it becomes an issue for them. And that could be in literally any neighborhood. So it's just,
it totally can. And even with that's another early getting counsel thing. You know, if you're buying in a community, in an HOA community or a condo community, and you have something you want to do with the property, I mean, I think the one I see most often is rentals, especially over the last couple of years. A lot of people invest, want to rent, but then there's a restriction. If you're walking into the transaction with that purpose, maybe your agent knows the community and they can give you some information, or they can ask those questions, get you an answer. But if that declaration or those rules and regulations are a little bit, they got a few steps to them, you know, that's an opportunity where you could get counsel to advise you on that. You know, it's just from my side of the desk, I always say, and I think I can kind of speak generically for real estate attorneys when it comes to that, we just don't see people early enough in these matters. And it's so much less expensive than people think to just ask that question. Like, no, it's not free to ask that question, right? But you can pay an attorney their hourly rate to go into that declaration or rules and regulations, read it, interpret it, send you some notes, and then you do what you will with those notes.
right.
I tend to get that in commercial real estate, but I don't get it out of residential real estate, unfortunately.
Well, I think it's probably from a lack of knowledge. See, like I personally didn't know that I could at least advise my clients to say, hey, here's all the rules, regulations, and everything. But if you here's somebody, you could seek some legal counsel, and they can go over all of this with you and give you the notes that you need. So that way, whatever your intended use for the property, you're educated, you know that. And not only because I'm not an attorney, I'm not educated like that. So I definitely can't give legal advice or anything. So, I think for a lack of education on the agent side and, the buyer side is probably, where that stems from. But I mean, now knowing that, that's something that I could help advise my clients too, because I mean, truly, I'm going to sift through those declarations and everything as best as I can. But it's not within my true realm to sift through a 75-page legal document and, tell them exactly what it says. It's just not realistic. And, I know it's a lot of time and a lot of effort and a lot of legal terminology that truly that I don't really understand sometimes, and they don't understand it.
I love telling agents this, and I tell them that a lot. It's not your job.
Yeah.
It's not, I've had transactions where, and I'm speaking from perspective that the agent has, personal knowledge or community knowledge, right? Or they've asked the association this recently. And so they know the answer because they've gotten it, but is it really your job to, sift through those things? Is it your job to explain, the FAR bar, right? Technically there's a level where that's legal advice. So the beauty of it is those questions, you can get rid of them by just saying, go to an attorney, they'll answer it, and not making it spooky. I think what's tough is a lot of us, just as humans, right? We're kind of poised to see attorneys as, the money pit. You go there, it's going to be thousands of dollars no matter what, or you can only go there when you have a problem. It's like the ER, you only go when there's a problem. Yeah. And I did a presentation recently where I remember using the phrase, that your transactions can get that physical instead of surgery. And that's kind of how it goes. There's definitely an ability to hand that stuff off early and get it off of your back. So you're not in that predicament where someone comes back and says, well, Kayla said this. And, and I've had a lot of matters where people have said that. I have very frequently have matters where when the client comes to me, even if that agent referred them, they want to know if that agent's liable. Now, obviously, as an attorney, I have to answer that question candidly. But the flip side is that just practically a lot of the times the answer is no. And so, like I said, I answer it candidly, but that question comes up super often because what people think of is they know you have, E&O policies and stuff like that. So they want to know, because I'm going to say, okay, fair to disclose issue. This is what we have to do. We have to, we're going to issue a demand, see if they, pay up just based on my letter. Sometimes it happens. It has happened to me before. But often from there, you're going into litigation. Here's how you pay that. Here's what it looks like. And we're going over it. And a lot of times people hear that and they go, I think my agent might have known, Sometimes they have facts that they relay that they really feel that happened. Sometimes it's kind of just an immediate response. And, I walk through it with them. And then usually we always get to, well, I really asked that because I know they have insurance. And you're describing to me this long drawn out process, whereas I think we can just go after their insurance and I can get my money, fix my house and move on. That happens with a lot of things. And so one of the ways for agents to kind of keep that off their backs is definitely to, exactly as you're saying, you see the 70-page document, you need to get a lawyer. Please don't assume that getting a lawyer is going to take you a month. Please don't assume it's going to be thousands of dollars. Here's some referrals. Here's some attorneys that I've talked to. Or I've
just advice. Yeah.
Mm-hmm.
Yeah. Hand it off. A lot of things like, say, my firm, and I know other real estate firms do the same thing, particularly in Tampa Bay. A lot of things we'll handle at the consultation. So we've booked a consultation. Yeah, it's a paid consultation. Again, most of us, especially who do litigation, are doing paid consultations, but you're paying for that. And then you typically, if it's not commercial, you typically will get your doc review included. So if you're coming in, do I have a case on failure to disclose? We book your consult, you pay the consult fee, you send all of your documents in. You're getting an answer at the consult. You're not getting theory at the consult. You're getting an answer as to what you've presented and what I think. And it runs the same for an example of, say, a HOA declaration or not issues, but questions on the FAR bar. If someone emails me, it's 12:30, right? Someone emails me at 1:00 and says, Tiffani, I'm having an issue with a client in a FAR bar. I feel like they're asking legal questions and I need someone to answer them. That's happened before. I'm going to say to my staff, can we fit this in today, or can I do the review over email and charge for my time? How can we make this happen? Because I know there's a transaction in progress. I'm not telling this person to wait a week or two to get that answer back, because I know it has to be done. So those kind of things happen at real estate firms, especially those of us who do transactions and litigation, because we're going to try to bring them in and get the answer without overcharging them for it.
Oh, that's great. Okay, ahead, Kayla. Sorry.
I just have a quick thing, but just kind of going back to getting the like documentation and everything and talking to these people earlier. I think that it's kind of our job as an agent as well to advise them, like, this is just like another inspection, but it's inspecting the documents to making sure that the house is something that you need to purchase, just like you're paying for your home inspection, you're paying for your appraisal, any other inspection that you do on the house that you have to pay for. I don't know what the fees are, but, even appraisals nowadays are, $600-700, sometimes even more. Your survey fee, that's a lot of
the
times
largest investment they're going to make of their life. And it's not something that is inexpensive to do. And then you get, my question was going to be like with investors, especially first-time investors, they want to purchase real estate to help grow themselves, but they're uneducated. So I was going to ask if you had any advice for somebody that's like a new investor, of things to look out for. Our areas are very popular with people coming and purchasing investment properties, Airbnbs, things like that, to be able to protect them for that first time investment that they're not used to necessarily doing. One of them being the HOA. Sometimes they buy these properties and they're like, okay, I'm going to go and I'm going to rent it. Well, no, you're not, because that's what the HOA, documents say, and now they don't know what to do. So other than read your HOA documents, would you have any things that come up a lot with like first-time investors that they don't remember to look for first?
Oh yeah. There's a lot that I see, and it's so sad, honestly. The first thing I see is people who go to, buy at auctions. And they don't realize that there's other, liens or other even active foreclosures on the property. And I've watched people lose their life savings that way. It's very sad to see. I think that there's also a lot of, unfortunately, as we know, a lot of misinformation on the internet. There's misinformation, and then there's information that's just not applicable to your state. Because in Florida, we just have particular laws. So you don't want to accidentally be watching someone on social media that's in New York or California, because then what they're saying is not going to apply for you in Florida. And that's something I see a lot. Well, I was watching this or that, and I'm like, I'm not going to say whether that person was good advice or not, but even if it was good, it's not about your state. So we see that. The next thing we see, of course, is people who want to invest and do it in the most budget conscious way that they can. And so they end up with the home that has defects. And then those defects turn out to be bigger than what they can afford to remedy. And then it becomes, okay, how do I flip this and get it off my hands? Or how do I, try to get it improved as best I can? And those are very tough decisions. That can be avoided, of course, by having a good inspection. If you've got an agent, listen to your agent, because you guys, are there to guide people as to what's a good investment and what is not. What it's about, what it's going to rent for, all of those things. People who go it along without, agent or any professional guidance, it's usually a budget decision or some kind of a decision they've made for their business. But I think the flip side is they have to kind of assume the risk that now you've got to educate yourself. Now you've got to know your documents yourself. And if you're not able to bring yourself up to the same level of knowledge that the whole professional team would have, if you had an agent, if you had an attorney, if you had an accountant, financial planner, if you're not able to get yourself up to that level of knowledge, now you have a huge risk in terms of what you're not going to know and errors that could be made in choosing the right property, choosing the right vendors to work with, and being able to get it to be a good investment. And again, if you make that mistake, you're going to really lose out on your whole investment. You may actually even take a loss and be worse than where you started. So while I don't necessarily say, oh, you've got to have all this money saved before you invest, because I'm an attorney, it's not my role to say that. I think people just have to understand the risk is there and you can't really skirt it if you're going to try to do the investing in a budget friendly way. I think, buying that property that has issues is one example. I've seen assignments, people trying to buy the houses out of probate kind of thing, or subject to transactions, or I think in that category. And I'll be transparent. A lot of times my firm does not assist on those, because a lot of times when I consult on them, I kind of see challenges and issues that could come up, and they're really significant. And the only way to cut past them is to really invest in your legal documents, really invest in counsel to get through it, right? Or you may not be able to get through the transaction. No one wants to hear that, and I get it. I'm a business person. I have two businesses, actually, a law firm and a separate business. So I get hearing, that is not a good time, but that makes situations worse when you keep going with it, even though it's not looking so great. And then the other thing I see when you clear all those hurdles is, you flip the property and you don't make good disclosures because you never lived in it, or you're not able to because you didn't live in it. So you got to make sure you check don't know, right? And then just be aware that that subsequent purchaser could always come back and claim that there was an issue. Whether they win or not is a different conversation, but they can say it. And then with the secondary part of that, whether you're flipping it or whether you're going to get a tenant, is how do you hold that property? Everyone and their mother holds properties in their personal names. I don't know why. Because I feel like we are at a point where there's enough info out there that says that's not a good idea.
That's not just a Florida thing.
Yeah, it's tough. And, there's cures for that. I don't always jump to the LLC. I tend to say LLC land trust. Which one's good for you? Could be a combo. And then we kind of talk through it to figure out what works. But, you want something. And the reason is, as a litigator, I can tell you, I won't say the majority. A lot of us are trained that when you are litigating against an LLC and you see this much cause to list an officer of that LLC on that complaint, you do it. That's just what we do. So a lot of people are like, what am I getting when I get the LLC? And I'm like, the law hasn't changed. You get what you get per the law. But in practice, the way that they're dealt with is different. And the risk that happens for investors is, are you, again, using prudent fiscal advice or having someone help you with that so that you maintain all your accounts separate, so that you're not commingling, so that you're all those things, right? Because if you do make a mistake in any of that, then to an extent, yeah, you haven't gotten anything out of an LLC. So if I think someone is, again, trying to be a little more budget conscious, or it's just not a good idea for some reason, or they really want anonymity and privacy, I tend to advise a land trust option as long as it makes sense for them. And something that I've done individually with my separate business is I have a separate business that will serve as trustee for land trusts, typically ones that happen to have been drafted by my firm, but someone could have their own land trust. They come to me, not my firm, but my separate business if they desire to, and we would just review it and see if it's something that could be helped with. And there's other professional trustees in Tampa Bay as well who don't charge as much as banks to do the same work. It's kind of like having a registered agent. And then with LLCs, I can't help but give the plug for that. With LLCs, everyone goes and opens, because it's easy. You hop on Sunbiz and you do it. And you've opened your business and, you get your EIN, or you go pay, my firm does that. You pay an attorney a little bit of money or a service a little bit of money to do it for you. And then you don't have like a separate business address or you don't have like a separate registered agent. And registered agent services are like $40 a month. You want a law firm like mine, I think I'm doing $300 or $360 a year for that service. So you can have, a law firm as a registered agent. Those things are available in a fairly budget conscious way. Virtual offices are available in a fairly budget conscious way. I advise against the UPS mailboxes because there is some indications in the Florida statutes and some case law that you're not really supposed to do that for business addresses anymore, and definitely not for registered agents. So I tend to say virtual office for that. Get your home address off of stuff, have that privacy and anonymity. You don't get to really hide from creditors in Florida. I think sometimes we feel like we do. You don't get to hide, but you get to take certain measures and precautions and try to isolate your personal assets. That's perfectly fine to do. Sometimes people are uncomfortable asking me about that, but I'm like, yeah, we can talk about that. And I'm going to tell you what you can and can't do. Because to me, it's about if that creditor or claim comes along, how are we going to manage it? How are we going to deal with it? If it is a bad claim and they're coming after you for no reason, there's ways to deal with that. But if it's a valid one, we're putting some stop gaps in place so that we have time and breathing room to figure out how we're going to deal with it. But umbrella insurance is not the end all be all. So I could go on forever about the investment thing, but a lot of what I get is, well, I got the umbrella insurance, I got the LLC. Okay, cool. Is your property even in the LLC? Like, if it wasn't deeded in, it's not in it, right? So those kind of things are really because it's sad to see, because it's like, oh my gosh, you didn't even put it in the business, or if you did, you didn't account for, the doc stamps or the taxation thing, all of that stuff we go into. That's why if you can afford counsel, get it. You can get on a payment plan with an attorney, get it, because it's just worth it instead of coming back after the fact. Because I deal with a lot of people who, can't quite afford the full legal process.
Sure.
And the question becomes, okay, well, now what do I do? Kind of like, who steps in for me and deals with this issue? How does the state come in? Probate, we do that a lot. Does the state come in? What happens? How does this work? And in Florida, the answer is nobody. If you're being sued and you can't afford counsel, you're going to have to represent yourself. You're going to have to do your best. Chances are you're going up against an attorney, unless it's a horrible case, you're probably not going to prevail. And no one's going to fix that for you, right? So they could get a default on you. Someone could sue you. You can't afford counsel. You don't submit an answer. You don't defend it successfully. They get a judgment, or they get a default judgment against you, and now you're in a really bad spot. Yes, we have protections in Florida for head of household and things like that, but and bad things can still happen. Very uncomfortable things can still happen. You can get sanctioned for certain things. I've been with clients who are going down that path. And it's very, very tough to watch it happen. And a lot of times people don't realize that it can happen. So again, that's that early intervention. You want to see stuff earlier, don't want to see it later.
And that's mingling. I think that happens quite a bit. People don't think about it. They're like, oh, okay, well, I'll just pay for it out of whatever, this account. And then as soon as it's found here, it's a mess.
It's tough to sit in front of them. I'm in my office right now, and they're right here, and I'm like, so you did it, and so here's what we got to do, because that happened, and I'm not judging you.
Because I'm
not judging you. It happened.
Some people don't know.
Right. So now what do we do?
Right?
It's
rewind.
It's a lot to deal with, and that's that situation where it's like, hey, you're gonna have to settle. What you fighting for?
Yeah.
It does happen.
Well, you're a plethora of knowledge.
Yeah.
And I could sit here and ask you a gazillion million questions, because I think that just the information that you've given us alone, and however long, 40 minutes, has been incredible. I actually want to, at some point in time, come up with like a specific topic. Maybe we could take like a whole show and go over like one specific type of incident and kind of talk to you about that.
I agree.
The knowledge is amazing.
Yeah. No, this has been great. And I'd say before we wrap up, since we didn't talk too much about the estate planning, I guess what I would ask is what is your advice to people, and when should they start planning? Like how early? When?
Lindsay knows the answer. It's now. It's now. And it feels so weird to say, right? But like anything can happen to anyone. And I'll try to be brief about what my goals are typically. If you're, I turned 30 on Friday. If you're in my age bracket, you're I feel like I'm still young. I'm going to say I'm young. You're a young single woman. I have a Yorkie. I have a mom. I have a granny. I don't have kids, right? So I love working with clients. I love working with everyone, but, I love working with clients like myself, because we're not planning for you to drop dead. We're planning for incapacity, car accident, illness. We learned in COVID, right, that people can be young and healthy, but be in the hospital for something, and then they can't handle their own affairs. And what happens a lot of time is, at my age bracket or even lower 20s, people think parents can automatically step in. People think boyfriend, girlfriend can automatically step in, and they can't. So we're really planning for that. Yeah, I'm planning for you to potentially die, but I'm also planning for if you have an illness, even a short-term illness, for things to be dealt with. For people who, in any age bracket that have minor kids, obviously we're planning to make sure the kids are good and make sure we know who the guardians would be. People who, are seasoned, we'll say, and, they've lived, maybe they're close to retirement, kids are, or, upper teens or grown, or they don't have any. Obviously, we're planning for them to no longer be around one day. And so we're structuring where things are going to go. And so, yeah, it is a start now, but the conversation looks different depending on your age bracket. The conversation I have with someone who kind of mirrors myself is different from someone who may mirror my mother or my grandmother. And so we just have age appropriate conversations about those things. And I think, again, it's usually more cost effective than people think. If I line up the cost of probate versus estate planning, particularly even if I don't do a trust-based plan or a plan that can legally avoid probate for you, I'll still structure something that practically should get you probate avoidance. And we go over all of that and how we can make it cost effective for the person who needs the services. But, everybody needs a will, right? Mm-hmm. Because everyone tells me, oh, I don't need one because I've looked at the Florida statutes default, because we do have a statute that says what your estate plan will be if you don't have one. It kind of mirrors a family tree. And everyone finds an exception every time I talk to someone. And I can give my own example. If your assets can't go down your tree to children, they're going to go backwards, right? So while I think my mom would want all of my stuff, there's certain things I would want to go to my cousins. There are certain things that, might be for my dog, or they might be put in trust for my dog's care, right? There's always some little thing that gets picked out that somebody wants to go in a different direction. There is no boyfriend, girlfriend, life partner clause in the Florida statutes. There's none. So that's
sorry to interrupt.
Oh, go ahead.
Okay. We've been in situations where we're like, oh, okay, great. Like they've had this ladybird deed. Well, guess what? The mortgage company wouldn't give them a payoff because they weren't on anything with the mortgage company. So we can't get any information. It's horrific. It's like one thing after another. So putting somebody in place to help you establish that has already had the experience and know all the different ins and outs of, what's going to happen. All right, fine. We have a ladybird in place, but we still need a power of attorney to be able to get documentation from the servicers and things like that people don't think about. They think that they're protected, and then it just turns into a snowball nightmare of trying to get other people to give you more information, and you're sitting duck until other things take place. But anyway,
sitting duck is a great description, because that's that one, especially on that probate EPN, you can't afford to fix it. I've had cases where someone comes in, they want to do estate planning for an elderly parent. There's a reason that we know that parent doesn't have capacity. They have a power of attorney from, 5 years ago that was pulled off Google. So it's got issues. Florida has specific provisions for power of attorney. Yep. Can't use it. Title company can't use it. Okay. Do you have a retainer to do guardianship over your mom? Do you want to do guardianship over your mom? Okay, now we're stuck, So, and no one's going to come fix it for you. If you can't, unfortunately, if you can't afford to fix it, there's some legal aid services available in this area, but they have a lot. Yeah. And so typically these things you have to live with it. They don't get fixed.
Right. So hire a professional. That's what their expertise is.
Always. So I think that going back to what Lindsay said, I think that, we should definitely have you on again, and maybe we can pick a topic, and, we kind of went over a lot of the failure to disclose today. So I think maybe next time we can get a little bit more into in depth into the probate and estate stuff, but we'll chat about that, when another good time is, and have you back on. But yes, you've been a plethora of knowledge and experience, and we really appreciate you coming on with us.
Yeah, sure.
You're welcome. You guys have been great hosts and great to chat with, great questions, because it's hard to figure out what to ask, right?
Yeah.
That's been amazing. And likewise, definitely wanting, I think probate's a great one to do some stuff on. I love talking about probate procedures. Probate's sad, but the procedures are interesting. They're not necessarily what people think. So I always like to kind of share behind the desk what's happening in probate.
Well, that's the part that nobody gets to see until they're in it. So
absolutely.
Yeah.
So
right.
what is the best way for anyone if they need to ask you some real estate questions, need some consult, or they just need to start planning their estate or whatever? What's the best way for somebody to contact you?
So if there is a need to set up a consultation, someone wanted to reach out to me to set up a consult, they could do that by email. My main email address is office@tktlaw.org. I'll give you my direct on here. My direct email is Tiffani with an I, first name, @tktlaw.org. There's also a page on my website where consults can be requested and documents can be uploaded. And I'm glad to be transparent about fees. My in-person consultations here at the Tampa office are $350, and the virtual, like phone, Zoom consults are $300. That is booking 1 hour of time because my hourly rate is $300. So it kind of matches up. Typically, if you got like a real estate issue, something to review, you're probably getting about 3 hours of my time on the back end because I'll have researched to death the issue, because that's just how I am. I'll have researched the issue to death before you see me. And then when you see me, I'm going to warn you that you're about to get a headache because I'm going to go down the law, I'm going to go down practice, I'm going to go everything I found, and then we're going to get to it. But, I try to provide value essentially. So that's how things could be sent in. And our phone number to the office is 813-337-7349. Requests can be sent there as well. You may hear from me, you may hear from staff, and they just kind of give you the next consult time and get you booked and set up and take down your info. And if something is rush, I don't mind being, advised of that so we can fit it in, as best we can. If what I've got available still isn't close enough, my staff and myself are going to start reaching out to other firms to see if we can, help connect with someone who's got that today availability. It can't always be done because these are law firms, but and the specialists are busy, but we try our best, understanding transactions, we try our best to connect people if we can't do it in the time frame that's needed.
Right. Well, I can't thank you enough. Thank you so much.
Yep.
Thanks for coming on. And
we'll be chatting soon.
Back on too soon.
Absolutely. Thank you.
All right. Everybody, make sure you like our YouTube page, like, share. Thank you.
Thank you.
Bye.